Well, ladies and gentlemen, we're now coming on to a very important session on police data sharing and access to private databases. I'm Timothy Kirkhope. I am the coordinator and spokesman for the European Conservative and Reformist Group on the LIBE Committee, and I'm a vice president of the CRIM, the Organised Crime Special Committee set up by the Parliament recently. Can I first thank, before I introduce the speakers, thank Jan Albrecht, who is our regulation rapporteur, and Dimitrios Droutas, the directive rapporteur, for facilitating this event. I think it has been a very successful couple of days so far, and much is to do with their initiative and the work that they are carrying out, which is complex but extremely thorough. And in the examination of the matters before us this morning, we are very fortunate to have with us speakers of this caliber. I start with Dr. von Notz, who is from the Committee of Internal Affairs of the German Bundestag. We have Monsieur Frédéric Tardif from the Interior Ministry in France. We have Mr. Joe Mcnamee, who is Executive Director of the European Digital Rights Organization. We have Mr. Eric Töpfer, researcher from the Deutsches Institut für Menschenrechte, or the Human Rights Institute in Germany. And we have Dr. Wiewiorowski, Inspector General for Personal Data Protection in Poland. That is, I think, a very exceptional list of speakers. I'm going to start with Dr. von Notz in just a moment, but can I just add one more thing? We sent out a questionnaire, as I'm sure you're aware, to national parliaments, asking them matters that they particularly wish to be brought to the attention of our speakers in the different sessions. And there are two questions that I'm going to just pose now, which perhaps our speakers will bear in mind. If it is not in line with what they had intended to say, then that's fine. But I would just like to mention these two things. There is a question, first of all, about any new framework. Should it also apply to purely domestic processing activities by law enforcement authorities, or should it be limited to cross-border cases only? And this was a question regarding, obviously, reverse discrimination and data protection as a common fundamental right arising from the Charter on Fundamental Rights and so on, and subsidiarity issues. The second question was that there is a growing tendency by law enforcement authorities to have access to data held by private companies for commercial purposes, and how is it possible to ensure a proper balance between law enforcement needs and the protection of fundamental rights? I wonder if our speakers could at least bear that in mind when they speak to us. I'm going to start, therefore, the proceedings by asking Dr. von Notz to talk to us on this theme. Dr. von Notz.
Well, thank you, Mr. Chairman, and thanks so much for the possibility to make here some remarks to that very thrilling and important discussion we have on those subjects. The protection of personal data in the field of police and judicial cooperation in criminal matters is not a folklore at the discretion of the ministers of the interior or the member states. It is an obligation deriving from the EU Charter of Fundamental Rights, the Treaty of the Functioning of the European Union, as well as from the national constitutions. As a member of the German Bundestag and as a member of the Green Party, all my positions taken are based on the conviction that the high data protection standards set by the data protection laws in my home country, the German Constitution and the elaborated case law of the German Constitutional Court harbor many valuable standards for the European development as well. This is especially true for the data retention, profiling and data mining, where our Constitutional Court clearly declared that the hurdles of the use of those instruments have to be extremely high and limited to very, very exceptional cases. What we need are high data protection standards all over Europe, and not only the cross-border flow of data between police and law enforcement authorities in Europe. Therefore, strong EU data protection legislation is absolutely necessary. For this reason, I want to underline that I do not sing from the same song sheet as those in Germany who see the harmonization of data protection legislation in Europe as a threat as such. The contrary is true. This harmonization is absolutely necessary. What we see today is an ever closer and intransparent cooperation and data exchange between police and law enforcement agencies all over Europe, complemented by more and more EU databases, EU agencies, and private and official data pools at the national level. And all those elements, authorities, agencies, and data pools are somehow interconnected with each other. I don't have to tell you anything about PRIM, the Swedish initiative, PNR, the Data Retention Directive, the access to the visa information system, and the processing of personal data by Frontex, to name only a few of the interdependent and overlapping EU instruments fostering the free exchange of personal data between police and law enforcement agencies. Therefore, we need strong EU data protection standards for domestic processing activities as well as for cross-border cases. Otherwise, we'll end up in a nightmare of uncontrolled overall surveillance. Moreover, I think the future EU legal instruments for data protection in the sector of police and criminal justice should include additional data protection standards for EU authorities and agencies as well. We face a dilemma and difficult political decisions. On the one hand, we really do need a new legal framework for the area of police and criminal justice. On the other hand, we cannot accept proposals allowing for forms of processing of personal data which are forbidden under our national constitution and the main principles of our national data protection legislation. The more we transfer personal data systematically to other EU countries in the context of security policy, the more our legal and political responsibility for breaches of fundamental rights through the processing of data somewhere elsewhere becomes evident. Our political and legal responsibility for the fundamental rights of the data subject does not stop at the physical German state border, nor are we allowed to be blind and process data non-regarding under which circumstances and data protection standards they have been collected in other EU countries. That's why we need a strong EU data protection legislation for the domestic level as well as for cross-border cases. I don't want to repeat the comments made by the Article 29 group, the European Data Protection Supervisor, and the civil society groups, especially Privacy International. I just want to mention briefly a few strengths and some weaknesses of the proposal from my point of view. We need a framework for the domestic processing as well as for the cross-border cases. I welcome the Commission's decision to include domestic processing as well as cross-border cases in the scope of the directive. Data protection at the domestic level unfortunately has been excluded from the scope of the 2008 framework decision under the German presidency. The argument brought forward at the moment, especially by the German government, that there is a lack of EU competence for data protection legislation for purely domestic activities under Article 16 of the Treaty on the Functioning of the European Union is a flimsy pretext in my point of view. Briefly, the EU standard fundamental right to data protection requires a comprehensive EU data protection legislation protecting the data subject all over Europe. This is only possible if we have EU legislation setting at least minimum standards for data protection at the domestic level. Thus, there can be no doubt the processing of data in the member states falls under the scope of union law in the tense of the data protection competence in Article 16 of the Treaty on the Functioning of the European Union. Access for police and law enforcement agencies to data held by private companies for commercial purposes is very problematic. In Germany, the use of external data pools for crime prevention and their subsequent use for data mining, screening and profiling are strictly limited through constitutional restraints. Our Constitutional Court, in its decision on the legitimacy of online surveillance tools, even went as far as to claim a new constitutional right to integrity and confidentiality of IT systems, which raises high hurdles for state access to any device designed to enable sophisticated forms of processing personal data, like, for instance, smartphones and their enabling infrastructure. Additional, both in its judgments on the so-called Rasterverhandlung and on the data retention of telecommunication data, the Constitutional Court limited the use of data pools collected for general or completely different purpose to exceptional cases of concrete danger of high-ranking, legally protected interests. This means that the general threat of terrorism cannot justify the pooling of data by the state or the use of private data pools held for commercial purposes. To give you an impression of the ranking of the Constitutional Court's argument in this respect, the Court underlined the potential discriminative effect of data mining, data screening and profiling. And the Court argued that overall surveillance of the individual is a breach of the right to human dignity as the underlying concept of our Constitution. Especially the Court claimed that there is a need for high security standards in any privately run infrastructure which is systematically being used for law enforcement purposes should be of high interest for European regulative perspective as well. Due to the ever closer interconnection between data pools and police and law enforcement authorities in Europe, this leads me to the very clear answer to the second question posed for this panel. We need precise EU provisions limiting to exceptional cases the use of external data pools, be they held by the state or private persons, and limiting to exceptional cases data mining, data screening and profiling. In this respect, the Commission's proposal for the Data Protection Directive is to this point extremely weak and therefore cannot be accepted to this point. Thanks so much for your attention.
Thank you very much indeed, and also for keeping to the agreed time as well. That's good. Thank you. Can I next ask Monsieur Tardy from the Interior Ministry in France to speak to us?
Je vous remercie, Monsieur le Député.
Thank you very much. It is a great honor to speak to you today about the question of access of the police and the gendarmerie to private databases. I'm speaking here as a representative of the French Ministry of the Interior, but also as an officer in the gendarmerie. Ladies and gentlemen, in a world which is more and more globalized, where individuals, products, services and capital can circulate more and more rapidly in this planetary village, The notion of a right to personal data protection has a special meaning. The explosion of telecommunications has created turbulence in the idea of frontiers as well, and in this case access to data is vital for investigatory services. Every day news shows that without this, it is not possible for the state to protect its citizens effectively. Indeed, crime is not restricted to just one country or one area of activity, so any information can be useful and can help an investigator to prevent a crime or to solve a crime. The information contains personal data. It could be the name, the address, the phone number, bank card number, or the PNR data, or even a fingerprint or a DNA marker. Some of this data can be collected in police computers or in commercial files. There is a real risk to privacy, and so this is where we need to draw the line. How can we draw a line between the legitimate right to protection of your personal data and the very fundamental right of a state to defend itself and to protect its citizens? So we need to combine the right of the investigator to get access to personal data and the need to frame that and put limits on that. Now, why does the investigator need this data? Well, because these files are a vital source of information on a daily basis, and nevertheless they are incomplete. Police data are a legal service which are consecrated nationally, internationally, at community level. And if we look at French law, the 1978 French law, which is the basic one on data protection, has restricted the use of police computers. So these police files allow the law enforcement agencies to search or investigate crimes, and there's a very rigorous regime. Article 26 of the 1978 law obliges the minister to submit to the supervisory authority in France, and if there are sensitive data, there is a draft decree which goes to the Secretary of State. Now, the police computer is vital for investigators. They need a maximum amount of investigation on those who might be prosecuted. So, if you look at the police records about someone or the police fingerprint files, these are the bedrock of what the investigators use on a daily basis, and they are very effective because various international and community agreements, such as the Prüm Treaty and the 2008 framework decision, allow for coordination between police forces. Nevertheless, this source of information may seem rather incomplete in some ways. On an operational basis, the investigators may need to consult commercial or private data collected by companies which weren't designed for the police to see them. Of course, the protection of personal data doesn't necessarily occur in an identical way for everybody. So what about access to such private databases? Well, internationally and community-wise, there has been an early stipulation, Directive 24/2006, stipulates that a certain amount of information must be supplied by private companies to the police. In the airlines, which of course were very much marked by 9/11, there is a legal framework for the collection of PNR data, passenger reservation data. The US, Australia and Canada have already set up processing for these PNR data and handing over those data to law enforcement agencies. In France, there is no desire to give free access to such data. The law is very stringent about this, and this is Article 26 of the 1978 law. So a police officer under the supervision of the Prosecutor General of the Republic, has access to all the data he needs to carry out his investigation. But that access is indirect and requires a certain time lapse. It's an effective measure. It's been set up by the 2006 24 directive set up by the community says that one can identify perpetrators of crimes through telephone records and or contacts with perpetrators, which will allow one to establish a network of criminals or the relationship between various individuals who are claiming never to have met each other. Phone investigations also will allow, it's a way of proving involvement in a crime if the person has moved in the same route as a vehicle which happens to have drugs in it, and allows the police to establish a connection between two different files, two different cases, and telephone investigations as well allow us to localize suspects and carry out surveillance. So this kind of data is very effective. To give you an example, in August 2008, the police had to investigate a missing person, a person who was 76, who was well known, and they'd gone to Spain. The person was known to the police and had come out of prison in April 2007, and the phone records showed that that person was in France and had contact with with a certain person also known to the police, and this identified the criminal as responsible for a murder. Without such phone records, one wouldn't have found that person, nor indeed linked them up with the homicide. There are more than 4 million phone records which have been consulted in the last year, so the consequences on private life requires rigorous supervision, and this supervision is binding. Everybody agrees that that's good, and it is carried out in two different ways. There's a legislative set of rules, and there's a more political set of rules governing supervision. The legislative side means that there is a restriction on the access to the database. The French law of 1998, amended in 2004, is a French law which distinguishes between the beneficiaries, as it were, and the persons concerned. The rules creating these files will depend, of course, on the caliber of the police officer and the need to know. Not every police officer of every rank has access to the data, and all of the access incidents are logged. There's also supervision through the Prosecutor General of the Republic, and you can't have access to private data without the supervision. So this gives us a safeguard for the person concerned, the person whose data are being accessed. And in the future, there might be a more simplified streamlining of this through access directly to digitalized data, which will allow a lot of streamlining, but there will still be a judicial authority supervising. There are indirect access rules as well regarding the people whose data is being accessed, so they can find out what is held on them, and they have that right of access. But I would say as well that the restriction on access by the police forces and law enforcement bodies to these databases is something which is supervised in a political way as well since 1998. Legislation on data protection in France is one of the most stringent in the EU and goes back a long way. When it comes to access to private data, we do not grant unlimited access. There is a strict legal framework of supervision. The state does not want to increase access, and it is particularly vigilant on the interconnection between files and the limitation of the retention time and on sensitive data being accessed. So it's all a question of expediency, and I think France has been very restrained and effective in its laws, and this moderation and balance idea is something that we have brought to the table of the negotiations on data protection. Thank you very much.
Thank you very much indeed, Monsieur Tardif. And can I just put on record here again my gratitude and that of many of my colleagues who visited Paris while we were dealing with some earlier issues, I think on PNR, and we received a very helpful guidance from your ministry on the way in which French authorities dealt with the issues of data and of the need to protect individuals in the use of that data. So I'm very grateful to you for that and for the cooperation you have given us when appropriate. So thank you very much. Can I now introduce Mr. Joe Mcnamee, who's the Executive Director of the European Digital Rights Organization. Mr. Mcnamee.
Thank you very much, and thank you very much for the invitation, and congratulations to the Parliament on such an amazingly impressive and successful event. For those of you who don't know European Digital Rights, we are an association of 32 digital civil rights organizations from 20 Council of Europe member states. In the short presentation, I will attempt to address the question asked by a humble lawyer here yesterday, which is whether the new data protection package will be able to deal with the exponential growth in data and processing possibilities. To do this, I will first look at the growth and the potential of profiling and then the proposed legal framework. The first thing to note when looking at the future-proofing of this package is the fact that the storage of data is becoming ever cheaper. We've already passed the point that companies either even reflect on whether or not to retain data because it's so cheap to retain data. To give you some quite interesting statistics that were developed by the Brookings Institute in the United States, $50 is how much it costs to buy the storage capacity to identify the location of each of 1 million people to 5 meters accuracy every 5 seconds, 5 minutes, every day for a full year. Similarly, at current prices, the storage of 1 year's worth of telephone conversations of 15 million people is about $2.5 million. And in 2016, this will drop to only $250,000. This ability to store virtually everything creates the potential to store and cross-reference all electronic communications and even to create the possibility of retrospective surveillance. This gets even more worrying in the context of profiling. Increased storage and processing capacity makes it possible to generate entirely new data out of separate pieces of data that are already stored. This has already led the Council of Europe and the Article 29 group to express their concerns about this. The UK's draft communications data bill is quite an interesting example in this regard, even though it's likely to be rejected by Parliament. It proposes the creation of what's been referred to as a profiling engine, which creates detailed profiles on all users of electronic communication systems. It then makes those profiles available for sophisticated data mining. This moves us away from what we currently understand by data retention, which is the collection of specific data that will be used on its own, to sets of data that allow individuals to be identified. In other words, the state would have the power to retrieve data from multiple company databases and then generate new data that is exponentially more intrusive than any data that any one company could collect. So, for example, one question that could be asked of this database is which politically interested individual, based on their browsing history, who's conservative based on their social media habits, with the higher than average salary based on their online shopping habits, was in the vicinity of the following address on 23rd of August 2012 at 11:32 a.m. based on their mobile phone records. This level of control would obviously be horrifying in the hands of a repressive regime, but how safe would it be in the hands of a trusted democratic government? Apologies for picking on the UK again, but in 2008, the UK government lost 36,989,300 items of personal data. Similarly, the UK is coming to terms with the abuse of private data by the press, facilitated by members of the police force, to gain access to the voicemails of politicians and other persons of interest to News Corporation. Each database, by its very existence, creates a security threat. And there are enough people in this room who lived under regimes that abused state surveillance to know why this is a problem. There are enough people in this room who have seen state and private data breaches to know why this is a problem. So, faced with these challenges, the question is, does the package protect us? Well, under the proposed regulation, there's one subtle but important new element. In the context of the exemptions for national policies based on national security, criminal offences, regulated professions, etc., measures based on profiling are listed in the number of measures which can be subjected to specific national provisions. In a borderless world, how predictable is the framework proposed by the regulation with such wide national discretion? Well, if the text is adopted as it stands, a citizen in any one European country will realise that their data are stored in various parts of the Union. They will know that some member states have comprehensive profiling, some will have none, some will have some. So, not knowing where in the single market their data is stored, they will know pretty much nothing about how their data may be being used by state authorities. And I have to say on this point that the working document produced by the rapporteur is unambitious on this point, and we strongly hope that the proposal that comes out subsequently from Mr. Albrecht will be substantially stronger. In this context, if we then look at the current situation regarding the Data Retention Directive, things get even worse. The Home Affairs Directorate General of the European Commission produced an implementation report that was shockingly honest. DG Home of the Commission originally used 3 justifications for proposing the Data Retention Directive. One of these was the need for cross-border availability of data. And unsurprisingly, it turned out, when they did the research, that it wasn't needed at all for cross-border access to data, because fewer than 1% of accesses to retained data were cross-border. Their explanation for this, however, is very interesting. They said that law enforcement agencies used domestic operators to gain access to the data of other member states because this was quicker and because there would not be, quote, any guarantee, end quote, of gaining access to the data if the agreed legal channels were used. Bearing this in mind, it is also interesting to read some operators' terms of service. One UK operator, owned by a Spanish company, permits itself in its terms of service to share data with unspecified third parties if they, quote, believe this is necessary. And this is where I would disagree with Commissioner Reding yesterday. Data retention is unfortunately not a German problem. It's a European problem, and it's going to continue to be a European problem until it's revised and ideally repealed. Finally, in this context, if we look at access by third countries to European data, in a society based on the rule of law, we should be able to rely on our governments to regulate access to our data. It would obviously be unacceptable for a third country, any third country, to gain access to European data without following agreed legal procedures. The third country data access that the USA permits itself under the Patriot Act and the FISA Amendment Act is simply unacceptable in a democratic society. FISA is particularly bad because it targets cloud data and political activity. DG Justice recognises this problem, and in their inter-service draft regulation, they proposed an Article 42 to regulate this and bring an end to this practice. However, before the text was even officially published, there was an avalanche of lobbying by the US authorities, and the entire Article 42 was deleted. Now, it's difficult to explain how bad this development is, and the only way I can think of explaining it is to imagine a situation that there was a draft US law aimed at promoting the interests of US citizens, and the European Commission came along, put pressure on the US government, and deleted the text aimed at protecting US citizens. Can you imagine the outrage? And can you explain the lack of outrage when the same thing happened in Europe? In conclusion, the Commission's proposals are generally strong. However, you can no more have a little bit of privacy than you can have a little bit of pregnancy. The gaps in the existing and proposed framework are too big. We've locked all of the windows and we've left the door open. It is unacceptable in a harmonising regulation to have such a broad range of exceptions in Article 21. It is unacceptable to ignore the Data Retention Directive, which is broken in principle and broken in application. And it is entirely unacceptable to tacitly accept unregulated access to European data by foreign powers. Thank you.
Thank you very much indeed, Mr. Mcnamee. And can I now ask Mr. Terpfer, Eric Terpfer, who is a researcher with the German Institute for Human Rights, to speak to us. Thank you.
Thank you, Mr. Chairman. I'm very grateful for the invitation and for the opportunity to provide an input to this debate as a researcher from the German Institute of Human Rights, and thus to raise the voice of a national human rights institution in this forum. Two questions are at stake at this panel. First, should the new framework also apply to domestic processing activities by law enforcement? My answer to this question is clearly yes. The exchange of information was always the core business of European police cooperation. Since the beginning of this cooperation in the mid-70s, the instruments and channels have multiplied significantly. With the Schengen Information System and Europol, with access to the visa information system and possibly to Eurodac for law enforcement purposes, with the availability of national data under the Prim decisions and the Swedish framework decision, and, not to forget, with the existence of an array of bilateral and multilateral cooperation agreements, the amount of data transfers has increased dramatically. These data flows are facilitated by a complex assemblage of networks and nodes such as the Sirene bureaus, Europol's Siena network, hundreds of liaison officers, and more than 30 police and customs cooperation centers in border regions of member states. Currently, around 1.5 million persons are filed in the Schengen Information System and in Europol's computer systems. Alone in Germany, the Schengen Information System is accessed around 70 million times each year. In 2010, the total number of searches in this system generated 38,000 hits on persons, entailing the transfer of supplementary personal information via the Sirene bureaus. The Europol information system was searched 110,000 times in 2011 and more than 330,000 operational messages were processed by Europol's Siena network between member states, Europol and third parties. Furthermore, it is generally estimated that the police and customs cooperation centers in Europe exchange on average 1 million pieces of information per year, as it was recently noted in the EU Council's Working Group on Information Exchange and Data Protection. In total, an increase in information exchange of 15 to 25% in the different channels was reported by 2009 and 2010 at the Infopolix conference organized under the Hungarian presidency last year. Whereas competent authorities in some member states already consider this increasing amount of data exchange as a challenge constraining their resources, it is clearly also a serious challenge for data protection, as all of these exchange data are originally collected in the member states. Although the legal instruments regulating the cross-border exchange of information for law enforcement purposes also include chapters on data protection, the collection and processing of data is usually regulated by national law. Issues of proportionality, storage times, or the rights of data subjects, the powers of supervisory authorities, all this is left to the member states. And in many cases, also the processing of data received from other member states is also left to national law, provided that the transferring authorities agree. Some say that a sufficient European framework for data protection in the area of law enforcement already exists, with the Council of Europe Convention 108 on the automated processing of personal data, and the 8 principles of the additional non-binding recommendation R8715 for the area of policing. However, efforts to convert the recommendations into a binding convention failed until today. This framework as the lowest common denominator is around 30 years old. It is not fit for the sophisticated forms of data processing which are possible in the 21st century. Moreover, it does neither specify powers of supervisory authorities, nor does it provide any firm mechanism for redress by data subjects. Thus, the very, very limited regulation of cross-border exchange by the EU Framework Decision of 2008 is not sufficient. With the lubrication of data flows, we are at risk to enter into a race to the bottom, where the lowest level of data protection in any member state is setting the standard. What we need are high standards also for domestic data processing activities by the police and other competent authorities. Therefore, the Commission's proposal for the directive, aiming also at the collection and processing within the member states, is most welcome. Given the increasing relevance of trans-border flows of data originating in the domestic realm, the critique that the direction taken by the Commission violates the principle of subsidiarity is not convincing, in particular when initiatives such as the European Investigation Order also aim to install far-reaching powers and duties of national law enforcement agencies. Much could be said about the details of the proposal of the directive, but I would like to concentrate only on 2 issues. I think that the rights of data subjects should be strengthened, in particular the right of access to data, which is the precondition for exercising other rights to rectification or deletion. As supervisory authorities, at least under current conditions, are only able to scratch at the surface when controlling the legality of data processing by the police, citizens should be empowered rather than inhibited to exercise their rights. Thus a revision of the proposed Articles 10, 12 and 13 should be considered. Secondly, the directive should be comprehensive. It should offer at least a realistic perspective to supplement existing data protection regulation and legal instruments on Schengen, Europol, etc., or at least it should prescribe standards for these instruments. A clear obligation to pursue such an objective is missing in Article 61. Finally, I'd like to say a few words on the second question: how can a proper balance between law enforcement needs and fundamental rights be ensured in face of the growing tendency by law enforcement of having access to data held by the private sector? I was surprised that the question is how and not if, as provisions on the exchange of data between the police and private actors are completely missing in the proposal for the directive. That such provisions are missing is very surprising given the current trend to impose rules for mandatory data retention to be accessed by law enforcement, for example in the area of telecommunication, banking or mobility. Other means of lengthening the arm of law enforcement that increasingly become relevant, in particular in times of austerity, are public-private partnerships, making private security companies or civil society actors the eyes and ears of the police. Such outsourcing of policing functions and the rising reliance of the police on private surveillance infrastructures demand a firm response and should be therefore addressed in the directive. First of all, the legality of data collection and processing needs to be guaranteed before data are accessed by the police. Otherwise, these new hybrid forms of public-private policing threaten to undermine established standards and the fundamental right of data protection. Thank you.
Thank you very much indeed. Before I move on to our final panel speaker, can I just say those who would like to raise questions or make some comments at the end, perhaps you could just make sure that we know, and that I'm going to take national parliamentarians first before we take members of this Parliament in those contributions. Thank you. I'm now going to give the floor to Dr. Wiewiorowski, who's the Inspector General for Personal Data Protection for Poland. Thank you.
Thank you, Mr. Chairman. My honourable colleagues in the panel, members of the European Parliament, members of the national parliaments, experts, specialists who are here in this room, and first of all, ladies and gentlemen, dear data subjects. You are data subjects. This is your data. We are not talking about a natural resource that we will find somewhere in the coal mine. We are not talking about the police databases that are stored somewhere in the world and that are only consisting the information about the criminals and about the suspects and probably about the witnesses. No, we are talking about our own data that is stored in many kinds of police databases according to domestic rules. This data is collected whenever you go abroad, whenever you go out of your country and you find yourself in any other of 27 European countries, you can be sure that some kind of data on you is either collected in the police databases or at least accessible for the police. That might be the data about traffic misdemeanors, of course, but this is also PNR, this is also custom data, this is also maritime passengers data. Probably that's a hotel data, probably that's a tax data, probably the data about reimbursement that you get from the public sector for the speeches that you have in other countries. Why do I say probably? Why do I say maybe as a data protection authority? Because I have no clue what the data is stored in the police databases all over Europe. I am data protection authority, but I'm one of 27 data protection authorities that should know 27 legal systems and 27 police systems existing in Europe. No, not 27. There are also autonomous regions. There are also the lands in some of the federal countries and provinces. Some of them have their own legislation about it. Can I multiplicate 27 data protection authorities plus the authorities for autonomous regions and lands, multiplied by the number of the countries and the number of the legal systems that exist, and moreover multiplied by the number of the enforcement authorities that exist in these countries. And in many of them, there are separate rules for the police and separate rules for the other police-like authorities. In my own country, there are 9 authorities like that. Well, okay, this is Poland, so probably it's only averagely 4 per country. So please multiply it, and when you come back to your country, ask your data protection supervisor, what does he know about the police databases in Poland? What does he know about these databases in Estonia, Lithuania, Malta, Portugal, Germany, France, and etc.? I have to say, I don't have enough knowledge to say to the citizens of my country that there is something like a minimum standard of the data protection in this area. Of course, there is a panel which is called Working Party for Police and Justice that has been created by the data protection agencies during the European Spring Conference on data protection authorities. But who of you heard about the body like that? Who of you think that this is the organ that may have any inspection powers in any European country? Of course, that is an exchange system for an information, but definitely this is not the organ that we would like to see. What is the minimum standard for Europe? Well, I would believe that the standards for the data protection in Germany is high. I would believe it's high in Denmark. This is not based on my real knowledge. This is rather based on my predictions about Germany and Denmark. Well, I know it is not right in UK because I also read the draft of the new law that Mr. Mcnamee was saying about. But fortunately, it was written in the language that I could follow. It was not written in Latvian, it was not written in Hungarian, not written in Greek, which would disable me to know anything about the legal standards which exist in these countries. And it's significant that we are right now in the room which is named after Joseph Ontol, the first prime minister, first non-communist prime minister of Hungary. It's important that we entered this building from the Esplanade Solidarity, named after the civic movement in my country that started the fights against the totalitarian regime. Moreover, it's very significant that this agora is named after Simone Veil, the first president of the European Parliament. Ms. Veil, being 17, was sent to the Auschwitz-Birkenau concentration camp and got the personal number that identified her in any kind of database of this totalitarian country. I come from the country where the democratic standards are relatively young. And I can imagine what can be done with the data which is stored by the authorities of the country. Of course, if you ask me, do I believe that the police and the enforcement bodies have a justifiable needs to collect the data, to make data mining, to collect big data, to use the knowledge management techniques in order to go through this data? I will answer you, yes, I do believe in it. This is the part of the security that I would like to get from my own country. And this is the part of the security that I would like to get in the European Union as well. But if yes, then it means that the minimal standard has to be kept on the European level. So I'm absolutely in favor of putting the data protection standard also to the domestic processing of data by police and the other bodies like that. Moreover, I'm absolutely sure that if we don't do it, we'll have more situations like they happened with, for example, Aleś Białacki, the dissident from Belarus, whose data has been transferred to Belarus from the domestic databases of certain European countries, above all also from my country, without any control from any independent body that could check what this data is to be used for. And for this reason, I also strongly support the idea of keeping the Article 60 inside the directive. They would reference to the multilateral and bilateral agreements that the countries are the parties of. And once again, look at the eastern part of the European Union. We are not talking about only about the transfer of data to United States, not only about transfer of data to India. We are also talking about everyday cooperation of the Finnish, Estonian, Latvian, Lithuanian, Polish, Slovak, Romanian, Bulgarian, and Hungarian and Greek police with the third countries, which are our neighboring countries in this part of the world, including Montenegro and Macedonia, who make a lot of efforts to meet the European standards in data protection, including Russia and Ukraine, who do some kind of development, and including Belarus, which does not do anything about it. And this everyday cooperation is vital for the normal work of the police and also the border guard in all these countries. But it has to be under the harmonized rules that exist in the European law. So let me address the final message, especially to those who supports the knowledge management techniques in the hands of police. For those who supports big data in the hands of police, data mining, index project, surveillance and surveillance for public good, profiling done by the police. For you all, the condition sine qua non to have all this in the police is to make the minimal standard on the European level on how this data is processed and what can be done what is the access to this data, what are the rules about profiling, and etc. For those who believe that we can limit the use of such techniques in the police, well, I personally don't believe we can limit, we can forbid to use these techniques. No, they are really necessary for the police. But if you believe that taking these tools out of the police is enough to secure our data, then you don't need to think about the directive as the legislative tool, but I hope you will support it anyway. But for those who are supporting this data processing by the police, conditions sine qua non is definitely the good common minimal standard for activities both on domestic level and with transport of data. And in my opinion, that is the European Union democratic standard that Joseph Ontol was talking about, that Solidarity was heading to, and that Simone Veil would also support when she thinks about the democratic society that the European Union should be the symbol of. Thank you.
Thank you very much indeed, and thank you to all our panel speakers for their introductory remarks. I'm going to pass on to questions and comments second. I certainly raised here myself in an earlier session concerns about the total amount of data that is being collected from all of us and processed and used, and the need for protection towards it. And I was amazed, I think you may have heard, some of you may have heard me say, that I attended a dinner purportedly on the subject of water resources, which would appear on the surface to have nothing to do with this subject, until I was told that actually the amount of water that would be required, extra water required, to cool the data processing centers of the world would exceed the amount of water that would be required to cool the power stations that were currently planned for the world, new power stations. And when I heard that, I have to say that I was pretty astonished, first of all, but also a little bit disturbed, frankly. And I think, therefore, the context of all our discussions here must be to make sure that where data is removed or taken from individuals, that it does have, at all levels and for all reasons, sufficient protection in its use, and indeed enough assurance as to its disposal. Now, I'm opening the session for questions and comments, and as I said, I will deal with any points from national parliaments first, and then I will move to the European Parliament, and then if we have time, I will open the questions to the more general audience. So we have, I think, first of all, a form in from Mr. Reichenbach of the German Bundestag, who I know wishes to contribute.
Vielen Dank, Herr Vorsitzender.
Thank you very much, Chairman. I have a question on the subject of controls. Now, if I've understood correctly, if we're talking about access to sensitive personal data by member states, which could be passed on to third countries, we need to ensure that there's going to be appropriate processing of that data, and there needs to be a proper supervision. And it's there where I have a number of doubts, and I'd like to know how that works with 34 and 38, the articles on control mechanisms. And of course, those are related to Articles 13 and 14. How are we going to implement that? For example, with the SWIFT agreement now, we've got sensitive data being passed on to third countries, and our rule is that Europol should be checking the observance of the standards. Now, what we've seen is that the American authorities have been classifying the data, and they're saying that this has been classified as by Europol, and there's nothing that we are actually capable of supervising. But if you look at Articles 13 and 14, how would this regulation ensure that together with the national legislation we wouldn't have external processing of the data in a third country which are not members of the European Union? How can we have any kind of supervision of that at all? I mean, I think the example of SWIFT is an example of precisely what shouldn't be done. Thank you.
Thank you very much. I don't know who would like to respond to that. Would any of you got a burning... Or shall I mean, a lot of comment there, which we've taken on board, I think. If you don't wish to comment directly to a point raised by somebody, we can always deal with that in the wrap-up later on, if you could just bear it in mind for the moment, please. Okay, thank you very much. I can now go to a member of the European Parliament. Yes, Mrs. Romero-Lopez first. Thank you.
Gracias. Thank you, Chair. Nikki said the American Treasury forced the SWIFT company to hand over banking information about European citizens in order to prosecute terrorism. Of course, the checks should have been carried out by Europol, but seeing as this data pertains to classified operations, checking whether or not that mechanism is working is very, very difficult for the European Parliament. I mean, this parliamentary scrutiny is virtually non-existent. As for PNR records and the agreements with the US, well, we're facing the exact same situation. The airlines are being forced by the American Home Office to submit PNR on European passengers, not just when they board planes in the US, but also when they fly over American airspace using these airlines. So now we're trying to set up a PNR register in Europe, but this gives rise to a very significant problem, because our philosophy of data protection doesn't exactly match that of the US. I've heard people from Germany, from France speak here today about data access for police authorities. It has to be allowed in under exceptional circumstances. And in the case of France, I've heard that it's also important for the judiciary. But that's always what's been happening with phone tapping, for example. There's no phone tapping without judicial intervention. But now we have a new method, which is data tracking. The police authorities are profiling data in order to track criminal behavior and in order to facilitate police investigations. This type of profiling does contain error. I don't know what the percentage might be, but it is not flawless. And a great legal expert, EDRi, said once that it's better to have a criminal on the street than having an innocent person in prison. Someone from Privacy International said, and there are 6 million innocent people registered in UK databases. So let us look at what's possible and what is realistic also for police exchanges. So if the procedures for exchanging police data and judicial data do not work, then how can we work? How can we use these types of profiling or data mining techniques that contain error? How can we then use exchange mechanisms that don't work? We can't really discuss this in depth, particularly as national parliament. How are we going to sort of subtract from this debate on police error, judicial error? How are we going to debate it here at the European Parliament without having discussed it at the national parliament level first? And it's important not just to have a bilateral agreement, because of course it is better to have a European directive, but why don't we start off with cooperation, like with the Broome Treaty that has been signed with certain countries? Let us study in depth these issues of profiling and mining, because we know that we have these automatic spiders, but when civil servants use them or analysts use them, we don't know what kind of criteria they're going to use. And they might face it, well, they might be subject to espionage or blackmail. How are we going to open us up to all that without having discussed this in depth first and without it having been discussed at national parliamentary level first?
Now I want to turn back to national parliaments and parliaments. I want Dr. Petri, who's the Data Protection Commissioner from Bavaria. Thank you.
Vielen Dank.
Thank you very much, Chairman. I just want to tell you about one case which is an example of what I experience every day. Imagine you've got a citizen who comes to me, and his problem is that his security authority has been processing data, but the authority hasn't been permitted to tell him which authorities the data has been sent to. So you've got various security authorities that have access to the data. So this might be through a common database, it might be through a joint procedure, but basically the number of security authorities that have access to this data increases exponentially. So these would all get access to the data for one individual citizen. But just imagine how the citizen can exercise his rights in this case. What does this mean for the citizen concerned? And what does the directive do in that case? Well, Article 1, Paragraph 2, B, sets the objective, which is that the exchange of personal data has to be made possible through harmonized standards. But then, if you've got a data transfer, what does the directive have to say? Article 11, Paragraph 1F of the directive says that the authority that has collected that data should inform the person concerned as to the recipients and the categories of the recipients. Well, okay, so the citizen tries to follow that directive and goes to the individual security authority or the possible security authority concerned, because of course it could be anything under a category, and the citizen would then have to basically try all possible security authorities to be able to have his rights observed. So just to exercise their right to information as to what has been received by the recipient authorities. Well, how can a citizen actually do that? I think that the mechanism that's stated in the directive puts too much trust in the mechanisms in the control authorities. But we need the control authorities, the security authorities, rather, to do this. At that stage, the security authorities that are working together should have a joint possibility for responding to citizens' rights if they find that basically the data has been sent to a huge number of different authorities. Thank you very much.
Thank you very much. If a panel would agree, I'm going to just continue. We've got another contribution here before. Perhaps they might all like to respond to what they're hearing, if they could bear with me on that. Jan Albrecht, who is, of course, the rapporteur on the regulation. Jan.
Thank you very much, Chair. I would like to point out something which is also referring to the regulation and the whole framework which you're talking on. The exceptions for the EU agencies in this whole area, because the EU agencies like Europol, Frontex, Eurojust, and so on, they are not covered by the regulation, they are not covered by the directive, because the directive implies standards for the member states. I don't see how a coherent data protection level will be reached in the field of police and justice cooperation if we still have a different group of agencies and databases, also like Eurodac and the Schengen Information System, which is not covered by this directive and by the regulation, and therefore it's a bit unclear how we will proceed with that. We will have the review of the Europol foundation in the upcoming year, and of course we had also for Frontex, but it's still very unclear how the standards are in these cases, and also my question to that would be in how far it would be possible, also in the course of our reform package on the table, to change that, and in how far it would be necessary also perhaps to strengthen the way how these agencies are controlled by national parliaments and by the independent data protection authorities. While I really have struggles to understand how we as parliamentarians in national parliaments and also in the European Parliament scrutinize the decisions in these agencies and in these databases existing and being already a very huge amount of common databases of all police and justice institutions. Thank you.
Thank you very much, Jan. What I intend to do now, if I could ask our panel perhaps to respond to what they have heard and maybe some of the questions if they can deal with those or make their further comments before I then offer a period of questioning to anyone else who is not part of the Parliament, unless there's any other colleagues who would like to raise questions, in which case we can come back to them again then. So can I perhaps go round the panel the way we started? Mr. von Notz, would you like to start us off?
Sure, thanks a lot. And maybe you allow me to answer in German to be a little bit more precise than in the wonderful English language. Ich wollte noch mal kurz
Yes, I just wanted to briefly respond to what Mr. Reichenbach said, and I'd also like to respond to Mrs. Lopez on PNR and data storage, data retention rather. Well, of course, it's a bit of a contradiction that in the process we're talking about today, these key issues have been left to one side. They're basically working in parallel, and of course this gives rise to huge contradictions. I think it's a shame that we're losing the opportunity of setting up a proper and effective common concept. We've got a very good procedure set out now. The European data protection system has impressed the people for whom data protection is important. But I think that it loses the credibility if you simply leave PNR and data retention to one side. I just don't think that that's logical. I could just say a few words about what Joe Mcnamee said, and also refer to the numbers that Mr. Töpfer raised. I think that they've really staked out the main problem. As legislators, should we be setting up a new age in terms of access to data? These are new possibilities that nobody could have imagined 10 years ago. How does that affect the protection of basic rights? These are such key issues that you can't say, okay, that's important for the work of the police, we've always been able to investigate in that manner, so we'll continue to do so. Well, no, actually here we see a real revolution in the way that technology and data are used. So we do need to adapt our legislation to the new age. Of course, this is also a response to increasing European integration. particularly in terms of freedom, security and rights. So I think that we're falling short at the moment, so we need to take the opportunity right now.
Mr. Tardif?
Oui, merci, Monsieur le Député.
Yes, thank you very much, Chair. Just to return to what Ms. Redding said yesterday, one of the key words here at this conference is trust. The trust which all European citizens should be able to have in all European institutions and bodies. I mean, when it comes to the security forces and the gendarmerie, do they need this data? Yes. But of course, their first and foremost concern is the protection of Europe's citizens in all aspects. We heard about errors in profiling. And yes, it's true, there are some errors, but they're minimal in police records. To take France as an example, in France, we go to considerable lengths to try to minimize and eliminate these errors. For example, recently, we've brought together both police and gendarmerie records, and in order to merge these two, when we established a mechanism to try to eliminate error, and this of course is all done under the scrutiny of the police authorities, but also a parliamentary committee on data protection. There was also mention of the absence in this directive and a posteriori checks. Currently, the French system has pre-checks, ex-ante checks, through declarations. The Commission on Data Protection issues it. It checks that the necessary safeguards are in place to ensure data protection for personal data. And that's the response to your question, really. Because, of course, I have to try to strike this balance between efficiency, security, and trust. That's what we're trying to do. Thank you.
Mr. Mcnamee.
Thank you. Could I just give a brief bit of advertising for a website we're going to launch next week called protectmydata.eu, which will contain our analysis of the regulation and proposed amendments. Could I break with protocol and ask the audience if there's anybody here who would say yes to the first of the two questions we were asked, that the new framework should only apply to purely domestic processing? Because I can't imagine what the other side of the argument is, so if somebody could enlighten us, that would be helpful for me. I agree completely with what Dr. Van Notz said. I think we need to fundamentally establish principles now. We've been dying by 1,000 cuts in the data protection area at the moment. One example is US PNR, and I'm afraid that's a failing of this House. If the EU-Australia agreement is proportionate and balanced, then the US agreement is patently illegal. And I know a lot of people in this House said it's better than nothing. If we don't have it, then what we have currently is worse. But consciously voting for an agreement that is, in my view, obviously disproportionate, obviously not necessary, and obviously an abuse of European fundamental rights, completely undermines the ability to do anything, because then we've got this cut here, we've got another cut there. As things currently stand, after this harmonised package is adopted, if I reflect on what's happening with my personal data in the internet environment, I will know that Article 15 of the Privacy Directive gives open-ended opportunities for member states to derogate. I know that the Data Retention Directive has completely failed to harmonise what it was supposed to be harmonising, and therefore doesn't even respect its own legal basis. I know that the legitimate interest exception in the data protection regulation is interpreted in widely different ways by different courts in the member states. I know that Article 2 and Article 21 of the regulation offer open-ended exceptions to the member states. I know that in addition to the regulation, we also have SWIFT, PNR, as well as Frontex, Eurodac, etc. We are a very long way from having a plan to having a harmonized approach, and we need to be vastly, vastly more ambitious. Thank you.
Mr. Terpler.
Zu der Frage von Herrn Reichenbach, ich bin mir nicht sicher, ob ich Sie richtig verstanden habe.
Yes, I'd like to check with Mr. Reichenbach. Is what you were saying that you saw there were dangers with transfers of data to third countries, so you felt we wouldn't be able to control it? Well, we've got a bilateral agreement between Germany and the USA, the Preventing of Serious Crime agreement, and I believe other countries have similar bilateral agreements. If you look at what's in the small print there, I don't get the feeling that the German standard of data protection is actually much better than the American standard. Well, of course, I mean, I've got absolutely no idea how you could properly control transfers to third countries. You mentioned the concept of trust. You have to have trust in the body of the third country. Well, I don't find that very satisfactory myself either, to be fair. But if you're talking about control within the European Union, of course, it would be nice if data protection agencies had better resources and if there was better coordination between them. I mean, the Schengen information and Eurodac and the Europol and the other information sharing systems, they're based in the Council, and I think that they've got 3 people responsible for that. I think we could actually improve that. Mr. Petrie, I found that your comment was very interesting indeed, because the information rights for citizens are an important aspect for me. I'd be quite interested to see how a practical proposal to solve that could work in practice.
Okay. Well, about control over what's going on in the agencies and in the databases which are created on the European level, of course there are joint supervisory bodies that are consisting of the representatives of the data protection agencies, all 27 of the European countries, and they are making supervisory work towards Europol, towards Eurodac, and the other databases, not all of them, but those that have the specific regulation in the legal acts. But actually most of the questions that have been asked here came to the problem of the exceptions, from the general rules which are to be set by the directive. I would personally agree 100% with Mr. Van Notz and with Mr. Mcnamee that it's a very good opportunity to take into consideration all of these exceptions and all of these special systems that have been created throughout the years. But being practical, I don't believe we would ever finish this discussion if we take all of these things on the same table. So being practical and also being in my previous life the clerk of the Ministry of Interior in my country, I can imagine that it's much better to have the general standard, general rules, general principles that are discussed right now, and then having this in mind and having the decision of the Parliament in mind, then go to the other legal acts. Retention directive is a very good example. There is very hard to find a person who is more against this directive than me. Well, I saw the worst possible implementation of this directive which happened in my country, and I'm absolutely against both this implementation and the directive itself. But at the same time, I can imagine that putting all the problems that arise in all these countries that already discussed the problem of the implementation of the retention directive on the table at the same time with the directive would be really counterproductive for the discussion on the directive. I can agree that the key word is trust. But once we do not have the real controlling system and the real principles for the processing of data in the domestic systems, then the trust is based on prejudices. So I'm very happy that my French colleague said so many words about the good way it is done in France. I'm very happy of that. I'm sorry I cannot say the same about the other countries. And when I worked for the Ministry of Interior, I've been told many times, and I inspected it many times, that there are clear rules that exist in Poland as well. The only problem is that these rules are not known outside of the Ministry of Interior and outside of the police. So right now, being the data protection authorities, I cannot confirm it anymore. I can tell you it was all right until I worked in the Ministry of Interior. Right now there is no real external control over that, and no European body has this control either. So the trust which is based on prejudices about the countries is the worst possible meaning of the European harmonization.
Thank you. I see that Baroness Ludford would like to contribute, so can I perhaps give her the floor?
Thank you very much, Chairman, and thank you for all the panellists for a very interesting discussion. I wasn't going to come in, but I just actually wanted to respond to something that Joe Mcnamee said. I agreed with almost everything that he said, but just on the US PNR agreement, very controversial in this House. After much reflection, in my group, and our group did not all vote the same way, I voted for it, and I did try to ask critics, well, what is your alternative? At the time, an answer came, then none. Quite honestly, given that it was a condition for the US to allow entry of people to their country, which they are completely at liberty to do, our leverage was not the greatest. And the alternative could have been complete legal chaos for the airlines. So I believe that it was our responsibility to vote for that agreement after the great work done by Soviet Union felt to improve it. And of course, the Parliament, I did not hesitate to reject the SWIFT agreement the first time round, which was much inferior. So opinions can differ on that. Obviously, we're in a much stronger position when it comes to legislation to control our own data on our own territory. And I completely take your point about the extraterritorial and jurisdiction that the US is asserting over cloud data and so on. I don't understand the timidity of the Commission on this matter. But when it comes to data retention, you referred, I don't want to make a UK discussion. I also hope that the proposed communications data bill will die a death at the hands of the Westminster Parliament. But, of course, one of the major issues there, both for that bill and national efforts and data retention, by the way, they prayed in aid the EU Data Retention Directive in bringing forward that bill. And the EU Data Retention Directive, although formally put forward by the European Commission, was very much pushed by the then Labour Home Secretary in the UK, Charles Clarke, under the UK presidency. So it was one of those policy laundering things through Brussels. But one of the biggest problems, of course, is not just the retention of the data, but who gets access to the data. And that is completely controlled. And the Data Retention Directive left that completely to national law. And our own law is a shambles in the UK. You know, tens of thousands of junior officials are allowed to get access to this data without any kind of judicial warrant. Just need some senior officer to, you know, tick a box. And so that is the biggest problem, or one of the biggest problems.
Thank you very much. I'm not able to comment on the coalition in the UK, but from time to time, Baroness Ludford and I coalesce here around certain matters, and certainly that was the case of our pragmatic approach to the US PNR. But anyway, I digress. I wonder, we've only got a few minutes, literally now. I'm sorry, we are running out of time very fast. Was there anybody who felt very strongly from the wider audience something they wanted to contribute very briefly? And then I could ask our panel quickly to respond, or are you all quite happy with There's a gentleman up at the rear of the room. Perhaps you'd like to just do so quickly, if you would, please.
Très simplement, Emilio De Capitani.
Quite simply, Emilio De Capitani again from the Three Group. I just wanted to remind everyone, with the entry into force of the Lisbon Treaty 3 years ago, there is a legal void on data protection in the so-called third pillar. This was partly covered by the framework decision, which will remain in force until December 1st, 2014. But as of mid-December 2014, all the legislation, all the regulations, and the Council of Europe Convention, which is used as a standard reference by the agencies and institutions, are due to be updated. And I wonder whether the current directive will be able to satisfy the needs at that stage. That on the 19th of September, in the document published by the Schengen Joint Supervisory Body, the authority calls the attention of all member states to trying to ensure the quality of data retained on wanted people, and this falls under Article 14 of the Convention. I think that right now the situation is a bit of a mess, as one would say in English. Really, that's just my impression, which I wanted to express to you.
Didn't have my glasses on when I called you just then. A former secretary of the Libre Committee. Thank you very much for that. Those comments. I'm not actually going to ask, unless anybody has a burning desire to come back. I think it's a good moment for us to bring the session to an end. I think it's been very useful, and I'm grateful for all the contributions, particularly from our panel, and indeed for those who contributed from elsewhere. Thank you very much indeed, ladies and gentlemen.